Welcome to Intuitive Defense. My name is Baker. I'm currently out of the country right now, but I wanted to provide an important update about our Second Amendment right. If you're not up to speed on what's been going on with the One Big Beautiful Bill, Congress just passed it and it should be going to the President's desk today to be signed. As it pertains to the Second Amendment, within the bill there is text on page 454, section 70436, that helps to restore freedoms by dropping the 1934 National Firearms Act transfer tax from $200 on suppressors and short barrel rifles to $0. Yes. Unfortunately, the Short Act, SBRs, and the Hearing Protection Act, Suppressors, which removed items from the NFA, was cut from the One Big Beautiful Bill by an unelected parliamentarian who, in my opinion, specifically targeted those because of an anti-2A agenda due to her party affiliation. Senate Republicans went with it even though they chose to ignore on other topics. That being said, Senate Republicans did replace it with a zero tax dollar on certain NFA items. That doesn't necessarily mean they stood up for our rights, it just means they compromised, which to me shows how weak they really are. But that's a whole other discussion and not the focus of this video. There was a possibility that after the parliamentarian denied the original text pertaining to NFA items, an amendment put forth by Republican Representative Andrew Clyde was going to be introduced. This amendment, called the Clyde Amendment, would have reintroduced the removal of certain NFA items under new and, in my opinion, better language. Unfortunately, and not a huge surprise, that didn't happen. Now, before moving on to what our options are now, let me provide some important information on court rulings from the past. In 1937, the U.S. Supreme Court stated the challenge to the NFA stood constitutionally because it wasn't a regulation, but a tax collected on certain items. Therefore, it can stand. Fast forward to present day, and now that the One Big Beautiful Bill has passed, with the tax amount collected on suppressors and SBRs being reduced to $0, but suppressors and SBRs are still subject to NFA restrictions and registrations. Is it still constitutional? I'm not too sure, but that's a decision for the courts to make. That being said, the goal all along has been dismemberment of the NFA and deregulation of NFA items. That is the win. Reducing the tax to $0 is a step forward, but not the win the people deserve. Of course, there are several downsides to this win in terms of reducing the tax. One of them, which is the largest downside, is the NFA still stands, and the possibility of a new, higher tax down the road being imposed by anti-2A politicians is there. Second, attacking the unconstitutional framework of non-taxed items still being regulated is a long road. It could potentially take years for that to work its way through the court system before it found its way to the Supreme Court, which they may or may not decide to hear at that point. Also, there is a possibility, depending on the Supreme Court justices who are on the bench at that time, they may not rule in favor of our rights, which at that point, we're screwed on the legality side. But all hope is not lost with the courts just yet. There is a possibility that a federal judge might rule that suppressors and SBRs that still fall under the control of the NFA with no tax being collected is unconstitutional. If that happens, we could potentially see a restoration of our freedoms and rights happen sooner. The third option, if there is no pro-Second Amendment decision made in any of the courts, it has to happen through legislation. But I don't see that being a viable or realistic option because it doesn't appear that Republican leaders want to stand up for the people. On the plus side, several pro-Second Amendment groups have stated that they will file lawsuits to remove suppressors and SBRs from the NFA as soon as the bill is signed into law by the President. A concern that I have moving forward is the verbiage within the bill. As of now, the tax is written as a $0 tax. What I would have liked to have seen written into the language is a no tax. Maybe this won't be an issue, but when it comes to legality, verbiage, and or the interpretation of it is very important. With a zero tax, there is still a tax dollar amount assigned to it. It's just set at zero. Technically, it is still a tax-controlled item because of the value designation. If the verbiage was no tax, then the verbiage deletes the tax designation. Therefore, it is a non-tax controlled item. That's just my interpretation of it. Keep in mind, I'm barely high school educated and I'm still entertained by campfires. So maybe my thought process on how the courts might justify the constitutionality of the NFA present day is wrong. Well, that's it for me, folks. I just wanted to provide this current event update. As things move forward and more information comes out on this topic, I will do a follow-up video. As always, we appreciate you checking out the channel. If you found this video informative, please share it with others. Have a great 4th of July, everyone, and we'll talk to you soon.